Howard III. I think we were at the guideline part. So let me grab all my notes in my guideline book. And that's good. All right. Oh, there they are. Okay, so Ms. Arnold, there was a sentencing memorandum regarding the guidelines. I think that's kind of where we were stopped before I got to the guidelines.
Correct.
Now, in the sentencing memorandum that I was provided, the dispute was on OV. I seriously think our recording system is dying in this courtroom.
That's okay. Phoebe moved the microphone over to her. I had it way over here, and then she moved it.
So I apologize, because I feel like I'm just telling people to yell at me all the time. All right. So on the sentencing memorandum, Ms. Walsh had scored the sentencing guidelines to be 0 to 17 on each count. There was an objection to OV 18. Let me get my OV 18. And OV 18 on the guideline scoring sheet was scored at 10 points. They object, saying it should be scored at 0. I did review the sentencing guidelines. Do you need a moment to do that?
No, Your Honor. I do have, I'm prepared to make an argument on that.
Okay, so would you like to make your argument on why it should be scored?
Sure. Your Honor, so OB18 is for operators' ability affected by drugs. In this case, you know, the evidence that's on the record, I believe, would only be contained within the PSI. There's absolutely no indication that within the PSI that his ability to was affected by drugs. And when you look up in the actual guideline books and, you know, the law surrounding it, it's not just affected in any way, but it's like they need to have a preponderance of the evidence that there is visible impairment or substantially lessened ability to drive. The case of People v. Smith, which I quoted in my brief, essentially indicates that even with evidence of internal possession in that case, that it was insufficient to score that guideline. I would also just note the case of People v. Kuhn kind of goes over this idea in reference to into medical marijuana. This is before we legalized recreational marijuana. People v. Kuhn analyzed, if you have immunity for internal possession of marijuana, can you be penalized? Can you be penalized for driving under the influence? And what Kuhn basically said is, well, just internal possession is not enough. When you're driving, there needs to be actual evidence of impairment. And so I believe Kuhn is directly applicable for this case, given that the language of immunity in the Michigan Medical Marijuana Act is the exact language of immunity in the MRTMA. As Ms. Arnold knows, and I think was one of the drafters of the MRTMA, the language of immunity is the same. And so therefore, there needs to be evidence of actual impairment, not just internal possession or evidence of recent use, but actual evidence that it impaired the operator's ability to drive. None of that is present in the record here, and I don't believe it's present in existence. So for those reasons, I believe it's improperly scored. If the scoring of guideline of OV18 is reduced, that would take the total OVs down from 20 points to 10 points, which does affect the guideline scoring. And I believe that the proper scoring, you know, the proper grid would be a 0 to 11 month grid rather than the 0 to 17 month grid.
Now, and this only applies to the police officer claim fourth degree. So Ms. Arnold, he pretty much quoted from the State Appellate Defender's annotated sentencing guideline manual, which People v. Smith is an unpublished opinion of the Court of Appeals issued April 20th, 2004, docket number 245357. So I don't know if you wanted to look at that.
I agree with all Mr. Rudo's legal arguments. He's completely correct in that regard, in our opinion. Kuhn says that, you know, just having marijuana in your system isn't enough. It requires that the marijuana have some effect on the person. So here, we think there's at least a preponderance of evidence to show that marijuana did have some effect on Mr. Howard, because the reckless driving itself is an indicia of impairment. He sped away from the police, was driving up to 124 miles an hour, and above and beyond the speeding itself, there was some erratic behavior in the driving itself. He passed a car on the shoulder of the road, crossed the center line several times. So I believe that goes to show impairment. Additionally, at the stop, and this is from the police report, his eyes were bloodshot and glassy. He had slurred speech, and he was unsteady on his feet. And I think that's at least enough to show that his ability to drive was substantially lessened. However, at the end of the day, the recommendation is still within guidelines, so we just defer to the court on the scoring.
If I just may
Yes.
briefly respond. First, Your Honor, the police report is not to be evidence in the case. There's substantial case law to that point. And essentially, I believe Ms. Arnold's argument is, well, he pled guilty to fleeing, which is, you know, the charged offense here, and that the fleeing in itself is evidence of impairment, which is clearly not true. Fleeing is a completely separate crime from an impaired driving crime. So I don't believe, one, using anything from the police report is appropriate, as it's hearsay and non-evidence, and not in the record in this case, and not, I would just note that those facts are not in the PSI, which is why there was no objection to the PSI, which is evidence in the case, the PSI itself. So those facts are not contained within the PSI and not part of the record in this case. And Your Honor, even those claims by the police, if Your Honor was to take those claims into account, are not evidence of impairment. Red eyes is not evidence of impairment of a lessened ability to drive. Slurred speech is not evidence of a lessened ability to drive. I don't believe any of those facts to be actually true when you watch the videos, but none of this is evidence in this case anyways. Impairment, as Your Honor well knows, requires a lessened ability to drive or a visibly impaired ability to drive. And the facts of this case are related to fleeing, not related to impairment. So thank you.
All right, thank you. All right, so I am in this case going to agree that OB 18 should be scored at 0, which would reduce the total OBs to 10. And then on that fleeing and eluding count, the sentencing guideline range would be 0 to 11. But on the controlled substance delivery and manufacture, the guidelines are 0 to 17. Any objection to that?
No, Your Honor.
No, Your Honor.
All right, and in the memorandum, it mentioned OB 19 should be scored at 0, but that was a typo, right?
Correct, Your Honor.
Okay.
I apologize.
No, it's okay, but I was like, I think I have this right. All right, okay. There,
We have the same manual.
I know. We give them out free. We give them to the PDs, we give them to the prosecutors, we give them to probation, they're awesome.
I'm pro judges, but object to prosecutors. So.
Well, you hugged her, so I don't know. Let's not do that again. All right, in determining the appropriate sentence in this case, I'm sorry, anything else you want to say, Ms. Arnold, on behalf of the people?
Judge, I did have a chance to review the memorandum, and I agree that Mr. Howard has taken substantial steps, it appears, towards rehabilitation. But I think the court can't ignore his record, and he does have, 4 prior drug-related incidents, and was on bond for an incident when this happened. So I do believe some upfront jail is certainly appropriate, given the behavior here and the amount of marijuana, which was significant, 21 pounds. The amount of cash Mr. Howard had on his person, over $7,000, which is indicia of trafficking. So I do think upfront jail is appropriate in this case.
All right. Mr. Daly?
Your Honor, when it comes to Mr. Howard's behavior, we take a look at his behavior over the last 5 years. He's always been employed, he's always had a job, and he's been suffering from pain. That was one of the reasons that he was using marijuana. He's now corrected that. He's seeing chiropractor, he's engaging in the medical services to control those issues. So I don't believe that's a problem at all. And it doesn't change the fact that when the court looks at what he's done and what his neighbors say, what everybody else says, it's clear that he is a true asset to the community. He has been and is going to continue to be. He's not going to change what he's been doing, which is being a constructive and positive member of the community. He helps people, he helps friends, he goes out of his way to be an asset to the community. And we expect that that's going to continue. He has been an excellent person to work with. There's nothing in the record any place at all to indicate that he does not now have all of these issues under control. He's not using drugs. He's not doing anything that he shouldn't be doing. And he's willing to be monitored and will be monitored for all of those things. So we'd ask the court to not give him any jail time for this.
Right. All right, counsel.
Your Honor, I believe Mr. Daly said it quite well, so I would just defer to my client. I believe he has some statements that he wishes to say.
All right, Mr. Howard, anything you want to say on your own behalf, and speak loudly?
No, I just wanted to say that I do take full responsibility for everything that did happen. I am more than sorry for everything. I do realize that I could have put other people in harm. I could have put myself in harm during these actions. And I'm going to continue to keep doing the same things I have been doing. That's going to NA meetings. I did a substance abuse evaluation. I did an education class, and I've actually been doing community service at a church as well too. And I plan to continue to keep doing these things and just focus to better myself and keep myself fit.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Mr. Howard, when I review the pre-sentence report, you know, as a parent of 6 and a grandparent of 11, people like you on the road terrify me, because that would be one of my spawn getting hit by your car, ran off the road, killed, or a police officer being killed. This was an incredibly stupid, an incredibly dangerous situation. So, you know, I hope you think about that. And one day you're going to have kids, if you haven't already, and you're going to realize how scary it is when you send your children out on the road and you have to worry about people like you doing this stuff. So it's sentence of the court that you will be placed on probation for 18 months. During that term of probation, you're not to violate any criminal laws, not to leave the state without the consent of the court. You're still living downriver?
Yes, sir.
Okay. You are to not use or possess alcohol or any illegal controlled substances, and no marijuana because of this case, because you're exploring other options for pain management, correct? All right. And you must drug test as required. Can't submit any fraudulent or adulterated samples. You must not use or possess any controlled substances or drug paraphernalia. If you live in a house where they have it, either they move out or you do, right? So no alcohol in your home, no illegal controlled substances, and no marijuana, all right? You must complete any outpatient or residential substance abuse treatment if preferred, an assessment if preferred. You must report to the probation officer monthly or as required. You're going to probably want to transfer your probation to Wayne County. And can you move them closer to the mic because we're not picking you up? And who do you live with?
I got a couple of friends that I live with, family friends.
Okay, sometimes Wayne County gets a little weird about transferring probation if you live with like a girlfriend or a buddy. So you're gonna have to figure that out. If And Miss Teskey, you did this PSI, or this was Miss Walsh. She was
This was, yeah,
concerned they would,
this was Miss Walsh, yep.
yeah. So you'll have to figure that out. You will need to report here next Tuesday, just to do the initial paperwork and look into the transfer, okay?
Okay.
You must notify the probation department of any change of address or employment status. You can't move without permission unless it's like an emergency situation. Obey all court orders not to engage in any assaultive, abusive, threatening, or intimidating behavior. Not to use any object as a weapon. Understand that if they feel that you have items in your home, your car, your wallet, or your phone that would violate your terms of probation, you do have the right to search that property. They do have a right to enter your home unannounced for probation supervision purposes. Let's see, you're currently employed, right?
Yes.
Full-time?
Yeah.
Okay. Must maintain employment. I don't like people to lose jobs because it's hard enough to get a job in our community. So I am going, and listen, I'm gonna order 12 months in Lenawee County Jail, defer. So if you violate probation, you're automatically gonna do your 12 months in Lenawee County Jail. Do you understand that?
Yes, I do.
Or I think the guidelines are 0 to 11, so 11 months. Is that what it was reduced to? 11 months in the Lenawee County Jail. And I'll defer that. You have 0 credit for time served. There's a crime victim assessment fee in the amount of $130, $30 per month supervision fee, 60 if we have to put a tether on you, $750 in court costs, $60 DNA fee, and then there is a $68 state cost per count for a total of $136. I expect monthly payments to be paid on that. Are you on probation again in Wayne County still?
I'm supposed to be starting a probation now.
All right, because you took care of that warrant?
Yeah.
Okay. All right, anything else, Ms. Teskey, I'm missing, I think?
Judge, she does have that she wants him to report Wednesday, 6/17 at 1:30.
Okay. I'm gonna dismiss the contempt of courts on the docket. And then next Wednesday morning at 1:30?
Yep.
Okay.
1:30 p.m.
So we're gonna need you here at 1:30. They may at that point process you to transfer. If we can't transfer, you're gonna have to report here. Okay? So my bailiff is gonna hand down to you, your notice of right to appellate review. He's gonna have you initial and date 1 copy for our records. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Okay, thank you.
Thank you.